Imagine this. The rules that govern your own home, your property, your whole neighborhood, they suddenly change. And not because of a vote, but because a handful of people on a board just decided. Well, today we're digging into a real-life story where that exact thing happened, and one homeowner decided he wasn't going to let it slide.
So it all comes down to this one huge question. Can your HOA just rewrite the playbook without asking you, the homeowners? That's precisely what was challenged here. So let's see what happened when they took it to court.
All right, so our story kicks off in this Arizona community called VVE Casa Grande. And right away, the HOA board makes a pretty bold move that ends up sparking a massive legal fight.
To really get what's going on here, we've got to rewind a bit. The community's main rules, their CC&Rs, were put in place way back in 1999. Flash forward to 2014 and 2015, the board tries to change those rules, but nope, the homeowners voted down. Twice. So what happens in 2018? The board decides to, try a different approach.
Yeah, so since they couldn't get the votes they needed, the board just went ahead and did it anyway. They wrote up a whole new document, they called it the Amended CC&Rs, and they went and filed it officially with the county. Just like that, it was the new law of the land, all without that pesky homeowner vote they couldn't get. And that one action, that's what started this whole fire.
Now, to figure out who was actually in the right here, we have to do something kind of boring but super important. We have to look at the community's own legal documents. And believe me, this is where it gets juicy. First off, what even are CC&Rs? Well, think of them as the constitution for the neighborhood. They're the master rule book. And they're not just suggestions either. These are legally binding contracts every single homeowner agrees to when they buy their house. They're a big deal. And boom, here it is. The absolute heart of the entire problem. The community's own rulebook seemed to be fighting with itself. On one side, you've got Section 10.4, which is crystal clear. If you want to change this main document, you need a 2/3 vote from everybody, period. But then you've got Section 3.4 over here, which says the board can create new association rules all by itself. The board saw that second part and basically decided it was a green light to do whatever they wanted. Well, the board's little maneuver did not go unnoticed. One homeowner decided no way and formally challenged them, setting up this classic David versus Goliath showdown. And this wasn't just, firing off an angry email. To take this fight to the next level, the homeowner, Douglas J. Karolak, had to put his money where his mouth was. He personally paid the $500 filing fee just to get the case in front of a judge. Okay, so here's how the arguments broke down. The homeowner's side was super simple. You guys changed the Constitution, the CC&Rs. To do that, you needed a 2/3 vote, and you didn't get it. Simple. But the HOA's defense was a bit more creative. They said, whoa, we didn't amend the Constitution. We just changed some day-to-day use restrictions, and our power to make association rules totally lets us do that.
See the problem? The whole thing hinged on this one detail. Was what the board did a massive fundamental amendment? Or was it just creating a small new rule? With the rulebook saying two different things, a judge had to step in and decide which rule was more important.
So after hearing both sides lay out their case, the administrative law judge Tammy Eigen here made her final call. And the verdict was a slam dunk. The judge found that the homeowner was 100% right. The HOA board had, without a doubt, acted improperly when it recorded those new rules. And this quote from the judge's decision just nails it. She basically said that whoever wrote these rules in the first place never, ever intended to give the board a secret back door to rewrite the entire community constitution without getting a vote from the homeowners. So here's how the judge broke it all down. She said, look, amending the main document, the CC&Rs, that's a huge deal. Adopting day-to-day association rules is a totally separate, much smaller thing. There's a reason they're in different parts of the rulebook. The bottom line, the board couldn't use its smaller power as a loophole to get around the much bigger, more important requirement. So case closed, right? A huge win for the little guy. The homeowner was right all along. Well, yeah. But the fine order from the judge came with a really surprising and really important catch.
Okay, so the official order starts out great for Mr. Karolak. First, he's officially declared the winner. He prevailed. And second, the HOA has to cut him a check for that $500 he paid to file the case. It felt like total victory.
But then came the twist. Despite ruling that the HOA had totally broken the rules, The judge said that her specific court didn't have the legal power to force the HOA to remove that improperly filed document from the official records. So the rule was declared illegal, but this order couldn't actually make it disappear. And that just leaves you scratching your head, doesn't it? The homeowner won. The board was proven wrong. But the rule they illegally created was still technically on the books. It really makes you wonder, if you can win the case but can't force the other side to undo what they did wrong, how much power do you really have?